Today, we're diving into a really fascinating puzzle in criminal law, defenses to liability. We're going to explore how someone can do something the law forbids, but still not be held criminally responsible for it.
I know what you're thinking. It sounds like some kind of legal loophole, right? Can you actually commit a crime, everybody agrees you did it, and still not be held liable? Well, the answer, in a few very specific cases, is yes. And the reason why gets to the very heart of how our justice system even defines guilt.
You see, criminal law isn't just about punishing bad actions. It's about punishing a guilty state of mind. Lawyers have a fancy Latin term for this, mens rea. It's all about the intent, the knowledge that what you're doing is wrong. So what happens when something, maybe a mental disease, maybe intoxication, maybe even just your age, prevents a person from actually forming that guilty mind? Well, that's exactly what we're digging into today.
So here's our roadmap. First, we'll talk about why guilt can even be questioned in the first place. Then we'll hit three huge defenses: insanity, intoxication, and infancy. And we'll wrap it all up by looking at how lawyers actually break these things down. Let's get started.
Okay, first up, let's lay the groundwork. There's a core idea that ties all of these defenses together. It's not about arguing the crime didn't happen. It's about questioning whether the person who did it can be fairly held responsible.
And this is the key right here. Criminal responsibility is a legal concept that says if you didn't have the required mental state for a crime, you just can't be held liable for it. And this isn't a medical thing, it's a legal judgment. It's about whether the defendant could truly understand what they were doing, their cognitive capacity, or if they could control their actions, their volitional capacity, at the exact moment the crime happened.
And that leads us perfectly into the most famous, and maybe the most misunderstood, defense out there: insanity. Now, this is absolutely crucial to get. Insanity is a legal term, not a medical one. A person can have a diagnosed mental illness and still be found legally sane.
You know, the legal definition of insanity has been argued about for centuries, and it's changed a lot over time. The whole thing really kicked off way back in 1843 with a guy named Daniel McNaughton. His case created the standard for over 100 years. But, as we started to understand the human mind better, the law tried to play catch-up, developing new tests to get a clearer picture.
So let's talk about the McNaughton rule. It's the oldest and still the most common test used in the United States. It's what we call a purely cognitive test. It's all about what you know. It really just asks two simple questions. First, because of a mental disease, did you not understand what you were physically doing? Like, did you think you were squeezing a lemon when you were actually hurting someone? Or second, even if you did know what you were doing, did you not know it was morally or legally wrong?
And this right here is the actual language from that landmark 1843 case. It sets the starting point. Everyone is presumed sane. To prove otherwise, the defense has to show this really profound defect of reason. And as you can imagine, that is a very, very high bar to clear.
This chart really does a fantastic job laying out how things have evolved. Just look at that top row, the core focus. Naughton, which we just covered, is all cognitive. It's about knowing. But then people started asking, what if someone knew an act was wrong but literally couldn't stop themselves? That's where that next column comes in, the irresistible impulse test. It added a volitional piece, your ability to control your actions. The later tests you see, like Durham and the Model Penal Code, basically tried to combine both of those ideas.
All right, next up, the defense of intoxication. This is another one where what most people think and what the law actually says are worlds apart. The idea that you can just say, oh, I was drunk, and get off the hook, that's pretty much a myth. It's an incredibly narrow and limited defense.
The first thing the law looks at is whether the intoxication was voluntary or involuntary. It's a huge distinction. So if someone was tricked or forced or had some crazy, unforeseeable reaction to prescription meds, that's involuntary intoxication. That's treated a lot like insanity and can be a defense to pretty much any crime. But if you chose to drink or take drugs, well, that's voluntary, and the law is way less forgiving.
So let's get right to it. Why isn't being drunk a get-out-of-jail-free card? The reason is that the law sees the very act of getting intoxicated as reckless. You're basically considered responsible for whatever happens as a result of that choice. But there is one really important exception. And that exception all comes down to the type of crime. Voluntary intoxication can only be a defense for what are called specific intent crimes. So think of it like this. Theft requires the specific intent to permanently deprive someone of their property. It's a goal beyond just the act of taking. Now compare that to a general intent crime like simple assault, where all you need is the intent to do the physical act, like swinging a fist. Voluntary intoxication might work as a defense for the first one, but almost never for the second. This case, People versus Hood, makes the rule crystal clear. So you have this guy, Hood, who is drunk and he shoots a police officer. He's charged with assault with a deadly weapon. His defense is basically, I was too drunk to have intended to do that. But the court said, no way. Assault is a general intent crime. The big takeaway is that the law considers the act of getting that drunk to be reckless all by itself. And for crimes like assault, that recklessness is enough to satisfy the guilty mind requirement, so the defense just doesn't fly.
Okay, our last defense is based on something way more straightforward. Age. The defense of infancy is all about recognizing that very young children just don't have the mental capacity to form criminal intent. And historically, the law had a pretty rigid set of rules for this.
This diagram shows the old common law approach perfectly. It wasn't about some deep psychological dive. It was a simple, strict system based on which of these three age brackets a kid fell into. Their legal ability to commit a crime was just presumed based on their age. That's it.
The rules were super clear-cut. If you were under 7, you were legally incapable of committing a crime. End of story. From 7 to 14, you were presumed to be incapable, but the prosecution could try to prove that you actually knew what you were doing was wrong. And then, once you hit 14, you're presumed to have the same criminal capacity as an adult.
Now, while those old common law rules are the foundation, the way we do things today is very different. Most places now have separate juvenile court systems. The whole focus shifts from punishment over to rehabilitation. And the decision to maybe transfer a minor to adult court for a really serious crime, well, that involves a much more complicated analysis than just looking at their age.
So, we've gone through insanity, intoxication, and infancy. Let's pull it all together now and look at how a lawyer might quickly spot these issues in a case, using some great tips from our source material.
It really just boils down to spotting a few key triggers in the facts. If a case mentions mental illness or delusions, your brain should immediately go to the insanity defense. If there's alcohol or drugs involved, you start asking, was it voluntary? And is this a specific or general intent crime? And if the defendant is a kid, of course, the infancy rules come right into play. The idea is to see the trigger and then apply the right legal framework.
And that really brings us full circle. I know these defenses can seem controversial, but they aren't just technicalities or loopholes. They represent the law trying to wrestle with a really fundamental question of fairness. Should we, as a society, punish someone who, because of mental disease or intoxication or just being a child, might not have had a truly guilty mind?
At the end of the day, these defenses force us to face a deep, difficult tension in the law. How do we make sure there's justice for victims and that the public is safe, while also sticking to the principle that we should only punish people who are truly to blame? You know, there are no easy answers here, and it's a balance our legal system is still debating today. Thanks for joining me.